think we're getting a lot of calls from people looking to get wills done, powers of attorney. Everyone's feeling very mortal right now, right? So, and because of that, we're trying to find out new ways to do things. So if you were to create a will prior to all of this, you simply give your instructions, grab two witnesses, independent of the will. So no beneficiaries, no beneficiary spouses, no one who's really named within the will should be acting as a witness. So you grab two individuals and you sign the will. You can still do that. So the question is, for people in long-term care facilities, are nurses willing to act as witnesses, which typically they're not?
Okay.
And where do you find those two independent witnesses outside of your primary caregivers? So the government has come out with the new emergency order that says, as long as one of the witnesses is a licensee, like licensed by the Law Society of Ontario, then you can do these witnessing electronically. The concern for us is that, again, a lot of seniors who are looking to take these steps don't have these social platforms or the internet capabilities or the understanding of how to use those systems. And then on the flip side is, if they do have that level of expertise, how do we make sure that on the other side of the camera, there's not someone with a gun saying, name me as your beneficiary and give me all of your jewelry, right? Like that's an extreme, obviously, but we don't know how to determine if there's any sort of undue influence. Is there people in the background that are not necessarily supposed to be there, right, when they're giving instructions?
So in this time then, if someone wanted to do a will and they're in a long-term care, or update their will, let's just say, and they're in a long-term care home, how would you go about then witnessing or sort of getting these changes implemented?
So I've had a couple of clients like that. Now, it's a bit different because if it's a client that I've never met and I've never done a capacity assessment, I've never spoken to them, because I typically determine capacity in an as is, where is situation, right? So when I go to see the client, if they're having a bad day and they don't have capacity, we don't do the documents. But if I attend at the client's place and they're, I know that they're not well generally, but they're able to tell me what the condition of their assets are, what they own and where they own them, all of those questions that gives me a sense of understanding of what they have and what they know, then we sign the document. So if it's a client that I've dealt with in the past who's calling me to say, this is what's happened, a child of mine has passed and I want to change my documents, then in those circumstances, because I've already gone through the whole exercise of confirming their identity, then I try and make sure if they have the ability to sign those electronically, as in, is there anyone that can set up the Skype or set up a FaceTime call for them that I can see them and speak to them and kind of get a sense of their surroundings and their health on that given day. Now, a complete stranger who comes in or calls in and says they want to make changes or create documents from scratch, in those circumstances, it's always a little bit more difficult because I don't have that past relationship. But same idea, we go through the questions and send out questionnaires to try and figure out where their assets are and where their mindset is.
Now, how would somebody change? So let's say they had their will done 30 years ago with some other lawyer, and now they come to you to make changes to it.
Yeah.
How do they, if they don't have their copy of the will, what can you do? If anything.
We reach out to previous counsel to find out if the will still exists in their office. So even if they may have given out the original to the client, typically older lawyers have a physical copy somewhere in their archives. Or for my office, I always have electronic copies with some kind of a note saying where the original is. There are two safes, one in Bowmanville, one in Marmora. So each of my office has a location to leave their will, should a client so choose. But if they do choose to take the original, then we just have a note in the file that says original was picked up on X date. So granted that the other counsel's records are okay, we should be able to track down at least a copy of the existing will.
Interesting. And then if someone wanted to then start the process of a will, then I guess the process typically is they go to your website, lawinmotion.ca, and there's probably a form on your site that they can fill out or call you. Like how do they start the process?
Yeah, so the forms are not online because they're what we don't want is people to download the form and then take it and run and believe that it's some kind of legal directive on how to create a document. So the process is they call in or they send an email and they get that information on the website, and it will direct them to get a copy of the questionnaire and then asks them very standard introductory questions: where they live, what the state of their assets are, who their beneficiaries are, if they know that, who they're interested in appointing as executor. The more information we can gather up front, the smoother the process goes once we start meeting with them online.